Hello friends, in the series on the income tax cases, today we will discuss a case regarding the validity of the penalty orders which have been passed without mentioning in the show cause notice that under which limb the penalty is going to be imposed on the assessee. The issue before Delhi ITAT C bench in the present case was that if the assessing officer has mentioned in the penalty notice that the penalty is for underreporting of income, but eventually imposes the penalty on the assessee for misreporting. So in that case, whether the penalty order will be valid in the eyes of law or not. This issue has been taken in the case of Jaina Marketing and Associates versus Deputy Commissioner of Income Tax, and this case has been reported in 120 ITR Tribunal at page number 154 on 20th March 2024. In the present case, various penalty orders were passed for the assessment year 17-18 to 19-20 under section 270A and section 271 AAB. Section 270A talks about the penalty for underreporting and misreporting of income, and section 271 AAB talks about the penalty in case of search matters. In the penalty proceedings, the assessing officer has given a show cause notice to the assessee that why the penalty should not be imposed on the assessee, and these penalty notices were mentioning about underreporting and not misreporting. But when penalty orders were passed, a penalty of 200% was levied on the assessee for misreporting. The assessee was challenging these notices on the ground that since in the penalty notices and the show cause notice the specific charge against the assessee has not been mentioned, so the penalty orders do not have any sanctity in the eyes of law. But the Commissioner of Income Tax upheld the order of the assessing officer, so the assessee was before the tribunal. When the tribunal heard the matter, the tribunal said that in the present case, the assessing officer has not mentioned that under which limb, under section 270A subsection 2, that is A to G, the penalty has been imposed. The show cause notice is not mentioning that under which limb of section 270A subsection 9, that is clause A to F, the penalty is going to be imposed on the assessee. The show cause notices are not mentioning that under which limb of section 271 AAB subsection 1, clause A to C, the penalty is going to be imposed, and under section 271 AAB subsection 1A, whether the penalty is going to be imposed under clause A or B, meaning thereby that the show cause notices were not mentioning the particular clause under which the assessing officer is going to impose the penalty. So until and unless the assessee is aware of the charge for which he is going to be penalized, the penalty order should not be passed. The tribunal said that the notices should be clear about the charge for which the penalty is going to be imposed. The tribunal said that the assessee could be only expected to give reply in respect of the show cause notice that was put to him, and the tribunal further said that the assessee could not be expected in any way to presume that the AO has recorded satisfaction in the quantum assessment order, meaning thereby that even if in the quantum assessment order the charge is specified, even then the AO should specify the charge under the penalty proceedings in the penalty notices and the show cause notice, because the tribunal said that the assessment proceedings and the penalty proceedings are totally separate and falls on different footing. The tribunal said that findings in the assessment proceedings are not conclusive of the penalty proceedings, and the tribunal also said that there is also the immunity clause under section 270A subsection 6. So there are various sections and there are various sub clauses in those sections. So the assessing officer should be very specific that under which section and under which clause the penalty is going to be imposed on the assessee. If this is not done, the penalty orders are not valid in the eyes of law. So the tribunal quashed the penalty orders. At the end of this video, once again I am repeating the name of the case. The name of the case is Jaina Marketing and Associates versus Deputy Commissioner of Income Tax, and this case has been reported in 120 ITR Tribunal at page number 154, and the date of the judgment is 20th March 2024. Thank you, friends.